All right, this presentation is about the core elements of an effective AOT program, and what I mean by that is what is the process like for putting one together, for rolling one out smoothly, and for keeping things going well. So there are several elements. I'm actually going to spend a lot of time on the first element because it is basically the most important one, and it's the one from which all of the other ones kind of follow. So the core element number one is program has buy-in from key leadership. And what that basically means is do you have all of the stakeholders who have an interest and a role to play in rolling out a good program? Do you have all of them identified? Do you have them in a situation where they're meeting frequently and they're able to put together, everybody can put forward where their perspective is in this, and it basically allows you to sort of troubleshoot in advance to make sure you have everything prepared before you start having clients go through the system, and then it gives you an opportunity to evaluate as you go along. So it's the most important and the first step, so we're going to spend a little time on it here. So who needs to be involved in the program buy-in stakeholder group? The first is going to be, you need to have the individual who's the most likely to be the petitioner is going to be the Human Services District person, which here you now call LGEs, local governing entities. So you need to have somebody from them because they're going to be either providing the services or they're going to be contracting with other service providers to actually do the case management or to do the actual medical services. So it's very important. Then you're going to need to have attorneys who represent the petitioner or the local governing entity, the parish or the municipality. You can do a program at any of these levels, but whoever the attorney is going to be, it's generally going to be whoever would typically do the petition for inpatient commitments. You can set that up individually in whatever your locality wants to do. You definitely can set that up with private attorneys that are appointed by the courts, but the most typical situation would be whoever it is that does the petitions for inpatient commitments is probably best suited to do the outpatient commitment petitions as well. So you want to have those attorneys involved because they're going to need to understand what is expected of them, what the procedure is, and how to put together the pleadings so that they have all of the things that are necessary. Obviously, this is going to also involve having the judge who's going to be doing the docket. Obviously, the judge has probably the most significant role to play, apart from the patient, in having this whole thing come together. And the black robe effect is obviously such a significant part of this that you definitely want to have the judge be a regular part of your conversations. As we all know, judges tend to be extremely busy, so a lot of times it happens in their courtroom, and that's the easiest way for them to make themselves available, and we usually work around their schedules. So the attorneys that would be representing the clients can vary. In Louisiana, the ones that are specifically contemplated is the Mental Health Service Agency, but it would not necessarily need to be that entity. There is also a role for private attorneys. If the individual wants to retain their own counsel, they have the right to do that under the statute. And if anyone is, if any of those attorneys are particularly interested, we certainly would welcome them to be part of a stakeholder group as well. You definitely have a role for criminal prosecuting attorneys if you want to roll out an AOT program as part of a diversion program. And this is because, generally speaking, if you're going to try to do an AOT program that diverts people out of the criminal justice system, that will require that the prosecutor use his discretion to do that, which means that they definitely need to be involved in this so that you can set it up so that that individual knows what kind of person, what kind of crimes would be eligible under that, and it can be part right from the get-go rather than trying to roll out a thing and then persuade the prosecutor that they're going to do that. Their input is invaluable if you're going to try to roll out that kind of a program. Law enforcement obviously is a very big part of this because if there is going to be any necessity for them to go out and pick somebody up in a protective order, they will be the people who do that generally under the statutes or in the codes. So you want them to understand exactly what the procedure is, what part of the statute enables them to do it, at what point they're going to be doing it, and then of course, if you have CIT trained individuals, which you do in Louisiana, you would want to have that be involved, because that is obviously the group of police officers that you're going to want to have involved in these kinds of cases, because they're the best able to de-escalate a situation and have things handled in an amicable manner. You want to have buy-in from treatment providers. Now, some of the time, that's going to be the county actually, or the parish actually is the service provider. The Human Services District actually does provide services. And then in other cases, it's going to be that you will have a contract with other service providers that are private, or might have a service contract with the hospital. And all of that stuff can be handled by private contract or by a memorandum of understanding, but it's stuff that you all want to have. The people who are going to provide the actual services should absolutely be a part of the planning process, so that it's clear for everybody all the way through the system and at every step of the way what is expected at every step, and what do you do if this happens. And a lot of times, people bring their own experience, and they will foresee obstacles that you might not see if you are not a part of that process. It's also crucial to have representation from peers. This can be peer counselors, it can be advocates for consumers that are in the community, it can be people who might be subject to AOT, then it can be family advocates. These are individuals, family members who probably have been pushing for AOT programs, have been the people in the community who have been trying to find some kind of a way to keep their loved ones in treatment. They have a lot of valuable insight. They can tell you a lot about what kind of things seem to already be getting in the way for people maintaining treatment. And they also provide a level of accountability for the system. Once the AOT docket rolls out and you've got people going through the system, the family advocates and the peer counselors and the peer advocates are in a good position to tell you whether or not the services are being provided the way that they should. And they can also give you some feedback about what doesn't seem to be running smoothly, what is unclear, whether or not people are clear about what they're supposed to do. So they are an invaluable part of the process, and definitely should be invited right at the early stages of planning. So the specific responsibilities for your LGEs obviously are going to be, this is the point at which somebody's going to be transitioning most of the time from an inpatient setting to an outpatient setting. So they're going to have a lot of a role to play in putting together what that discharge plan looks like, what the actual transition looks like, what services are available in the community, and making sure that you've kind of contemplated what the specific hurdles that particular person has to face are, and trying to incorporate that into the written treatment plan. And then, so this is, in the broad sense, this is a coordination between the mental health services community and the courts. So this is the group that is going to be carrying out what the court is saying is going to be ordered to have happen. So they obviously need to be involved at every stage to make sure that the services are available and that they're incorporated into the planning, and that they are very clear about what's expected of them and how that they're supposed to liaise with the courts, in addition to what needs to be done if they want to change or modify the plan in the future. The attorneys for the petitioners they're responsible for putting together a petition that indicates that the person satisfies the criteria for AOT. They obviously also have a role to play in doing an initial assessment of whether or not the person qualifies. You obviously would not want to bring a petition for somebody who clearly doesn't satisfy the criteria. So as you're putting together the petition, you're going to be also assessing what witnesses there might be that would support the case that you're making. Now, this can be under a time constraint. Right now, obviously, it's 5 days, but generally speaking, you're going to at least make sure that you have the medical testimony lined up and ready, because that is what is absolutely necessary in order to do an AOT order through the court. But it can also be, you can also find other witnesses, family members, et cetera, or whoever else might be helpful in making your case. And then you're also going to be putting together the motions and requests for hearings, and basically you're the person who procedurally is going to help the people who are not lawyers make sure that they're complying with what is required in order to have this be a court-ordered process. The judge, as I said, is basically the rock star of this whole process. It's the relationship between the court and the individual that really provides the most impetus for the person to remain treated and to remain in the community and to have goals towards being able to succeed, and then just the ability to speak directly to the judge and feel heard by the court. So it's definitely, it's also making sure that the process runs smoothly, that all of the procedural requirements are met, and because this is a process that involves actually curbing people's specific liberties, you have to make sure all the due process requirements are met if you don't want to be overturned or if you don't want to create any bad will with the patient. So that is also a significant role that the judge plays. And it's something that on the front end, when you're actually setting these programs up, you can save yourself a lot of headaches if you have the judge engaged and the attorneys engaged to make sure that the things that you develop for the pleadings and the forms comply with all of the requirements of the statute right out of the gate. The treatment provider obviously is going to be the one to whom the person is handed, the baton's going to be handed off to this person in order to make sure that the person is receiving the treatment that is required. So this can be medication, it can be outpatient treatment, it can be day programming, and it's whatever is specified in the written treatment plan. And so it's a lot of logistical planning to make sure that you are keeping track of the individual, making sure that they're keeping their appointments, setting appointments, finding the service providers, and all of the detailed things that the person is probably going to need some assistance with. They're also in the position, because they're providing the ongoing care, they're the first people who will be aware of it if a person starts to not comply with the treatment plan. So they are a very big part of the early intervention. If somebody starts to maybe look like they're having some compliance issues, or if they start to look like there's something that is not working about how the plan is, this is going to be the group of people, apart from the family members and the patient themselves, who's going to be the most quickly aware that there's something that isn't working that needs to be addressed. So they also have a significant role to play in continuing to motivate people to get back into compliance, to continue with compliance, and then they have the role of advising the court monitor, advising the AOT monitor, that it might be something that requires a hearing, or there's something that might need to be tweaked about the plan. So these are the people that have the ongoing relationship with the consumer. So it's very important that they're a part of the planning process so that they know exactly what it's supposed to look like, and that makes it much more likely that they're going to notice when somebody starts to fall off of their adherence. So for the Crisis Center Psychiatric Emergency Department Administrator, these a lot of times are not going to be the long-term inpatient folks who are the petitioners, but you are authorized under statute to be a petitioner if you are in an emergency department, or if you are in a psychiatric receiving center, which would basically be like a crisis stabilization center. If there is any plan that those individuals are going to be actually doing petitions, it is just as important for them to be a part of the stakeholder group as anyone in the inpatient or the LGE would be, because they have that same role and they need to follow the same formalities under the statute. So it's important that they understand exactly what those are. Inpatient treatment providers are also one of the specifically identified individual classes of people who can file these petitions. Now, a lot of times it's probably going to be the LGE that files, but it is also possible for it to be the director or a designee from the inpatient facility. They're going to be in the best position if a person is coming from an inpatient setting, they're going to be in the best position to have somebody put together an affidavit that is based on their medical observations. They've got somebody inpatient, so it's going to be crucial that they are able to really understand, what the requirements are for what has to be in a written treatment plan, what has to be in a physician's affidavit in order to file this, and what the procedures are. How many days do you have to do that? When you're looking back on a patient's medical record, how many hospitalizations within how long are you looking at? So that's the kind of the role for the inpatient treatment provider, and it's also one of the reasons why it's important that they be involved. So if you're putting together a flow chart where everybody can kind of see this is what this process looks like, they need to be there because they're at the front end of the system. Okay, law enforcement, as I said before, it's important that they're there because they do have a role in either taking people into custody or possibly transporting. So that sort of depends by statute whether or not you do it that way. And it's important that they also understand that this is a form of outpatient civil commitment. This is not actually just a voluntary treatment plan, so there's legal effect here, and they need to understand that there are responsibilities that that they will have under the statute if it does turn out that the person needs to be brought in for an evaluation. It's not something that they have the choice of doing. It's under the statute. So it's important if you're going to be asking them to be a part of the process, it makes sense for them to be a part of the process right at the beginning so they know what to anticipate and how many people they might be looking at. So it's best for them to be actively engaged. It's also going to be, if you do actually look at rolling out an AOT program that's going to have anything to do with the criminal justice system, like a diversion program or a after jail kind of program with AOT, then this, law enforcement's going to be involved with that as more, they'll be playing the role of like the inpatient treatment provider in that scenario. So it's really, really great to have them involved right in the beginning so that they can see how what they would be doing parallels what people are already doing from the inpatient setting. Criminal prosecutor, as I said, so if you're going to do a diversion, you want to have the criminal prosecutor a part of what you're doing because everything absolutely depends on their discretion. It actually, at the point when you would be diverting somebody out of the criminal justice system and into an AOT program, they have not seen a judge yet. The only person who has had anything to do with whether or not that person is going to proceed into the criminal justice system or as opposed to ending up in a civil commitment court is the prosecutor. So if you want to roll out one of these things, the criminal prosecutor has to understand that they have this authority under the law, what it looks like, and they need to put together some kind of a policy about who is eligible for this kind of a diversion program. As a result, it's really important that if you have any interest in doing this as a diversion, that the person should be a part of your planning committee as soon as you can possibly get them into it. I already talked a little bit about this, so I won't go through it too much, but generally speaking, if you, as Brian suggested, respectful treatment is the goal, and it's something that increases the ability of the patient to succeed in this setting. So if you are going to do this kind of a program, it is crucial that you have people who represent the consumer's interests, the peers of that consumer, and the family members who are, obviously living right there with the person and are very much affected by what the decisions are. You want to have those people involved so that there's accountability towards the community, towards the consumer, and these people can really advocate to make sure that that happens. And they can also really be of great help in providing education for the community at large. And this can include NAMI groups, and there is a family-to-family AOT criteria, AOT curriculum that definitely can be a part of any NAMI group's programming and education and outreach efforts. So it's definitely really important that you engage this particular group as part of your initial stakeholder group and keep them engaged throughout the process. It's a really good way for you to know how it's working. Is the outcome what it should be? Core element 2, so once you've convened your super group of stakeholders, you want to put together a schedule where you're meeting at least quarterly. When you're initially putting together a program, it's going to be more frequent than that because there's going to be a lot of things. I think the groups that have been meeting already in order to kind of put together an AOT program have kind of discovered that the initial few times that you get together, you generate a lot more questions than you do answers, and it's a lot of stuff that you haven't necessarily thought of, didn't really realize you were going to have to figure out. And it's not until you try to actually go walk yourself through the program that you're like, oh, what does the statute mean when it says that this happens? Does that actually mean that you're coming back to court another time? What does notice mean? What does that look like? So it's definitely probably going to be front-loaded. You're going to start out with more frequent meetings, but after you've actually started having people go through the docket, you're still going to want to meet at least quarterly in order to be able to keep an eye on the data, make sure that you're evaluating the program as you go and identifying what things could be improved upon, because you will continue to find things that you can improve throughout the entire life of the program. And the more that you do that, the more you can make it responsive to people who are in the system, the better it's going to work. Element 3, agreed upon written policies, procedures, and forms are in place. I know that the attorneys in this room probably understand this better than anyone. We are not, as a group of people, very comfortable doing things if we have to write up our own stuff from scratch. It is not a comfortable position. Like if it's a new statute, one that you're not really familiar with, you're going to want to have pleadings that that people have had a chance to look at, that have been tested, that appear to cover everything that's in the statute. And then once you've got that, you're a lot more comfortable going into court. So it's very, very helpful and makes everything go a lot more smoothly if you put together those forms, put together pleadings, put together flowcharts like the one that I put together. Each one of those you can put together individually for the locality that you develop. It's going to be a little bit different for every single place because you have different people, different roles. Some people will find that, like, hey, it makes more sense to have the AOT monitor be a part of the Human Services District. Some might find that it works better for the AOT monitor to be part of the courts. And all of that is fine as long as it's permissible under the code. And then you just want to make sure that everybody who's a part of that system has really mapped out what that looks like, and you can identify, I need these forms. I want to have a form that people can fill out as opposed to doing a pleading. And you could do that. It's all, you want to set it up so that it's comfortable for the people who are working within the system, so it will be different from place to place. But the more of that you can put together in advance, the more comfortable everyone's going to be with it. And then you definitely, you're going to want to have, organizational charts are very helpful, just like flow charts are, but having a list of contacts and actually meeting regularly so that everybody starts to get to know each other. One of the things that I really discovered when I was working with a diversion program in Virginia is that there were a lot of individuals from the Human Services Department, there were a lot of people from law enforcement, and they didn't really know each other, but they got to know each other really well through the course of doing this diversion program, and it got to the point where it was pretty easy for them to really troubleshoot these programs because, hey, it's different. I'm calling up, Lieutenant Morgan, who I know because we talk all the time and we go to these stakeholder meetings, and you'll find that the more that these groups get together and meet and you kind of know more about each other's departments, you have a better sense of how you can actually put together a program that works. You can help solve each other's problems. You'll even probably find that there are some budget interactions that are very interesting to study. So definitely put together a list of contacts and make sure everybody's got it so that everybody can, feel free to contact somebody from the sheriff's department or contact somebody from the coroner's office to ask a question. And the more that happens, the more everyone is going to be working together towards this mutual goal. Education materials can be developed and should be developed as a way of making sure that the public is aware of the fact that this tool is available and making sure that people who work in the departments are aware that it's available and how it's supposed to work. That's kind of an ongoing process, and you sort of figure out who needs to receive these things as a part of meeting regularly. But it's definitely, and we, by the way, have a lot of these materials. We've developed them for lots of different jurisdictions at the county, city, state level. So we're happy to help with that kind of educational material. I'm not going to go through this ad nauseum, but you can basically, as you're meeting, you're gonna want to identify. We met with the Orleans Parish group by phone on Wednesday, and when we did that, we talked through the process of, okay, so let's walk through the process of an individual coming from inpatient care and going through this process. So let's go through that petition process. And then we walked through the process of what does it look like if you're coming from a community referral. And then we walked through the process of what does that look like if you go to, if you do the community referral and the person doesn't show up for court. What does it look like if the person shows up for court but they won't agree to be examined? So that is the kind of, if you walk through those things and then you have answers to those questions, then you're ready for whatever happens. There's a limited number of things that you have to be prepared for, but if you are prepared for them, then you don't freak out when it happens. And the more comfortable everybody is with this, the more you're going to get a therapeutic effect. Okay, so the core element 4, AOT monitor serves as liaison between treatment team and court. So basically, I mean, like I said before, the overview of this is basically a marriage between the court system and the treatment system. In the best case scenario, we've got a treatment system that has the tools that they need, and then the court is an additional tool that they can use for a particular segment of the population for which it is useful. And the AOT monitor is sort of the individual who is tasked with kind of keeping that marriage going. So you're going to keep an eye on, keep track of who is under order. You're tracking the progress of the individuals who are in the system. If there's, communication that needs to happen between the court system and the human services system, you've got a single point of contact. You know exactly who you're going to call. That person is going to have more information about what's going on than anyone else, and it just provides a certain amount of clarity. Now, some AOT programs throughout the country do this as like a full-time position, and some, this will be like juggling around things, so that there's a particular person who takes this on in addition to what they're already doing, and some of it is somebody's already doing a lot of this kind of stuff, and you're just kind of finalizing this and putting it into like an actual formal kind of description of what is expected of an AOT monitor. In the packet of materials that you received this morning, there's a couple of job descriptions that I included. Whether or not you're actually planning to hire somebody to do this, or you have funding to hire a full-time person to be an AOT court monitor, those job descriptions, they're from 2 different jurisdictions, kind of identifies what this person's role is supposed to be. So, and you can figure out who's going to do that. It can be whoever works best for your particular locality, but the function that they have is to just kind of be the liaison between the court system and the mental health system, and they're going to be it makes it possible to have the single point of contact that makes the whole thing work more efficiently, rather than everybody figuring out who they need to call all the time. So educating stakeholders in the community, we talked about a little bit, but it's basically as once you get this thing set up and you're ready to roll it out and you're ready to have people go through the system, it is also important to make sure that people know that this is a thing that is available. Now, this is obviously, Nicola's Law was passed in 2008. It is obviously 2018, and we're getting around to implementing. And a lot of that is because we didn't really put in place, a public education group. We didn't have implementation programs. We didn't do the work to show people how to implement these, how to roll these out. And the public, some people knew about it because it was in the news. So they knew that Nicola's Law was a thing that was available. And as a result, what we ended up with was a couple situations where family members who were at their wits' end and really wanted to come up with a solution for their families went to the courts, and they maybe got an order, and it didn't go anywhere. And the reason it didn't go anywhere is because there wasn't any cooperation between, there's nothing set up, there was no program in place, and you didn't have a situation where there was any sense of what that looks like if you get one of these orders. So this is why the public education and outreach is so important, is because you want to do this as a program. So there's a sense for all of the people who are stakeholders in this process of what it looks like to start one of these dockets, run people through the system, and attach them to services. And everybody needs to be on board with it, or it doesn't work. So that's what we're doing right now. We're putting together groups who are going to start rolling out programs. We're going to start putting people through the system, and we're going to make sure that we do it in a sensible way where people can address their issues, and they can continuously be evaluating the system to make sure that it's working. And NAMI can be really great about this. A lot of people know that, if you have a loved one who starts experiencing mental health issues and people don't really know what to do, one of the first groups that they're going to reach out to is going to be NAMI. It's very helpful then if NAMI is aware of the fact that this is one of the tools that are available, what it means, and how you qualify for it. Core element 6, so basically outcome satisfaction and gaps in resources systemically tracked and evaluated. This is basically, and it makes perfect sense, of course, as you once you have this constructed and put together, you have a sense of how this is going to run and who's going to be involved. Obviously, the next step is to start having people go through the docket, get into treatment, and be tracked in the outpatient setting by their treatment providers. Well, once you do that, you're in a position to start tracking whether or not this is working. And if it's not working, you can start to try to identify by asking the people who are involved, what's not working? Why is this not working? Was this a transportation issue? Are you not getting to appointments because we didn't figure out a way to get you there? Are you not able to participate in this because you're just having, the medication is ineffective and we're not finding a way for the doctor to be aware of the fact that it's ineffective. So this is a crucial part. If you want this to work and if you want people to have buy-in, it has to be respectful treatment, right? So respectful treatment means that you're listening to the people who are in the system and you're paying attention to what their feedback is. So you want to build that stuff into the program right along the way. You also want to start collecting as much data as you can, because if you can show that your program is really working, you can apply for funds. And you can start getting private funds and federal funds. The more you're able to demonstrate that something is working, the more people are going to want to be involved with it and the more funds you're going to get from the state, federal, private, whatever. And obviously, as I said, it's respectful treatment. So you basically want to make sure that you're also collecting that data. And a lot of times people just forget to ask this stuff. It's not so much that you aren't providing respectful treatment, but it is very helpful to collect data, to ask people. Before you leave, you're going to be filling out an evaluation of this course, and you're going to want to do the same thing for these programs. You want to make sure that you're asking people, what is your experience like while you're in this? Do you feel respected? Do you feel coerced? You want answers to those questions, because if there's a way that you can change things and it makes the experience better for the family or better for the consumer, you definitely want to do that. And it usually doesn't involve a huge change in the program. So core element 7, system in place for identifying and addressing gaps in resources, areas for improvement. This is kind of the same as core element 6, but it's just, essentially a more formalized thing where you want to put together, okay, let's kind of figure what our measures are going to be for success. Are we going to start tracking the number of days that a person spends inpatient before, maybe a year before they were in an AOT program versus a year after? Or are you going to start counting whether, has this person been rearrested? What does success look like and how do we measure that? The more that you can build that in on the front end so that you can measure it all the way from the beginning to the end, the more likely you are going to be able to really make the argument to lawmakers and funders that this is a program that's working and we have evidence to show that. Here are the numbers that we have that show that this is having an effect. And if it's not having an effect, then you can figure, okay, something's not working right. We have to reevaluate here. So that's why you want to really put some thought into how you're going to evaluate success right on the front end. So this is our website, and I want to just go through real quickly how you want to go about accessing our various forms, because we do have sort of a data bank of different job descriptions and flow charts and organizational charts. So while you're in the process of, as a stakeholder group, of putting this stuff together, we've got a lot of examples that you can look at. So on our main website, you want to go to the tab that says Fixing the System. Within that, there's Implementing AOT Laws, and within that, there's Documents and Forms for AOT Implementation. There's a lot of stuff on there. We're putting more stuff on there all the time. There's an implementation manual from Ohio that we have definitely, we put together for Ohio. I want to make the offer that, if we can find funding and we can, have everybody engaged and it's something that people want to do, we are interested in working with people here to put together a Louisiana implementation manual or working to put together a little bench book for judges so that they have kind of a real quick reference guide. We've done that in other places, and it's very useful. So if people are interested in doing that, and if that's something that you work on or something that you know who would be a good person to work on that with, get in touch with me. I've got business cards flowing all over the place in here, so everybody should just grab one. And if you can think of something that you think we should work on with you, please get in touch, and we're happy to do it. Okay, so I'm going to turn it over to Brian. Mm-hmm. absolutely. I mean, like, and Janet has great, she's always talking about how supportive NAMI is and in Louisiana, and we are always happy to work with them because their family-to-family program is a great way to reach out to family members, and they are really well set up to educate and to do public outreach.
I also say, Lisa mentioned that a part of the stakeholder group should include families who have a stake in it because their loved ones are in it. NAMI is the obvious place to look for those particular people to be part of your stakeholder group.
Great, so we're going to move into Brian's next presentation, and we're just working on a little AV issue, so hopefully we'll be able to get audio through the main speakers. I just heard that audio through the main, but anyway, yeah. So, but while they're working on that, I just wanted to mention that, this is part 2 of the AOT series, and it's not the end, right? So what the next steps are going to be to really encourage everyone to start their own AOT work groups in whatever region they're in, and Healing Minds and NOLA will help coordinate and facilitate those groups. And so make sure, if you are interested in that, you take my business card, which is on the registration table outside, or you can just ask me for it, and we're more than happy to do everything in our power to help folks get started with that.
Okay, everybody. Thanks. So in this next segment, we're going to talk even more in depth than we have about the black robe effect, about the special role of the judge in making this whole process work. As we've said now ad infinitum, you're probably sick of hearing it. It's really the key to this process. It is the secret sauce of AOT. The idea that people generally, by their nature, for the most part, connect with a judge, take seriously what they're asked to do by a judge, and want to satisfy what a judge has asked of them. And we've talked a lot about the fact that this program is a collaboration between the court and the treatment system, and while that's absolutely true, I also think it's worth taking a step back to note that it's a funny kind of a collaboration. I think at one point it was described as a marriage, and there's a real fine line here that an AOT judge has to walk, because once you reach the point that somebody is part of the program, yeah, absolutely, the court and the treatment system have to work hand in hand. But at the same time, the treatment system is, when they're petitioning for AOT, they are a litigant before the court. The court's not supposed to be married to the litigant. So, the judge always has to keep in mind that there is a burden of proof that must be met. There is due process that must be respected. And the judge cannot order AOT unless he or she is satisfied by clear and convincing evidence, which is pretty high evidence standard beyond what we normally have in civil cases, that all of the criteria have been met. And once you get past that point, you move to the second phase, and we'll do a hearing in a little while, a simulated hearing to give you a sense of this. The judge then has to be satisfied that this treatment plan that its partner, the system, has presented is appropriate and meets the person's needs and is not just pie in the sky, that there are actually providers who have been lined up. And once you have this plan in place, there are also going to be opportunities where the judge might have to get a little ticked off at the treatment system, right? If there's some perception that they are not holding up their end of the bargain. So for all the talk about this being a collaboration and a partnership, it's something that must be balanced, and it takes some understanding on the judge's part that partnership only goes so far, because the court must be fair and to be respected and have legitimacy in the eyes of the respondent, the person going through this process. court must be perceived as fair. So let's now take a look. We've talked a lot about what this looks like. Let's actually look at a little bit of video from San Antonio, Texas. This is my good pal, Judge Oscar Kazin, who I know some of you had the opportunity to hear from when he was here in Louisiana not too long ago, talking about his experiences running the AOT court in his county, Bexar County, Texas. And we're going to take a look at Judge Kazin. These are some clips, I should say, from a film that my organization, Treatment Advocacy Center, has made. It's called Stopping the Revolving Door. There's a 30-minute film about AOT, and if you want to see the whole thing, which I highly recommend, it's also a very good tool to help other stakeholders who you may want to rope into your efforts to get AOT going. Ask them to take a look at it. The name of the film is also the web address, so if you go to stoppingtherevolvingdoor.com, you will find this film to use however you wish. And what I've done here is I've taken just a few scenes, 3 scenes, clips from it, that show Judge Kazin in action with patients in different situations. So I'm going to tell you what, I'm going to walk down there and stop the video at certain points. So the first scene is going to be a short clip from a formal hearing that is held in a case where the respondent is contesting that they meet the criteria, and there is a necessity for the court then to hold a full formal hearing in the courtroom. And you will see how Judge Kazin interacts with all the folks there. Just go full screen. Loud enough.
She still has some residual delusions that I don't expect to go away at any point, but she has at least reached a point where I think we can manage her as an outpatient. The problem with her in the years past, though, is very, very, very poor compliance of outpatient care.
Judge Oscar Kazin is signing a court order mandating outpatient treatment for someone who has spent a lifetime in and out of psychiatric hospitals. The goal is to stop that revolving door. It's called Assisted Outpatient Treatment, AOT.
Everyone that comes through the door has to make these promises, okay? We promise you that we'll provide you with the team. We'll be there whenever you need us. We'll get housing and transportation, and we'll be following and helping you in any way you need, all right?
Thank you, sir.
But I just need 3 promises back from you. So rule 1, be honest. Rule 2, be where you gotta be.
Yes, sir.
The third one's the toughest one, okay? I'm gonna encourage you through this whole thing. Take your meds exactly like you're supposed to take your meds when you're supposed to take your meds.
Okay, so there you saw Judge Kazin in a formal hearing. Now you're going to see him in a more informal setting around a conference table with someone who, wait, don't go away, I'll need you to hold that mic again. With someone who has agreed to enter the program through a settlement agreement and is not contesting the petition. And you'll hear him say a lot of the same things you heard before. It's really not that different. Biggest difference is the setting.
There's a treatment team for each participant: psychiatrist, caseworker, attorney, sheriff's deputy, each accountable for the patient's progress to Judge Kazin. And unlike treatment ordered by mental health courts, people in this program do not have to commit a crime to qualify for help. Today, Leticia Jaramillo meets her assisted outpatient team for the first time.
Yeah, I'm Judge Kazin. We've talked a few times, and I'm really glad that things are going good for you right now, okay?
And my name is Leticia Jaramillo, and I'm here to get help too.
All right, we're here to give you
I need help. I mean, I try to do it on my own, but it doesn't prevail, you know.
Well, we're glad you're here.
There's a theory on how the active oversight of a judge can help the mentally ill. It's called the black robe effect.
When you sit a patient at the end of a table and they know they're going to meet with that judge, that sense of authority, that sense of accountability, it comes through to them. And believe it or not, they actually pay attention. I only have 3 little promises that I need from you, just 3,
Okay.
to make this work, okay?
Okay.
Number 1, when you come in here and you talk to us, you have to be completely honest about everything, okay?
Okay.
Because I can't help you if you don't talk to us. The second thing, you have to be where you have to be, and that means make your appointments. This is probably the most important, if of all of the promises, it's the most important one I need from you. You promise us that you'll take your meds.
Oh, yeah, like I agree.
Good job, that was it. It was that easy.
Yeah. Yeah, it's easy, but it's not easy.
I know.
It's easy to say, but it's still coming down on me.
This
Okay. So this third clip is basically a graduation ceremony. This is someone who has reached the end of their time on AOT. The determination has been made. They no longer need the court order in their life to stay on the course that they're working well on. And here you're going to see this person receive a lot of, I think, self-esteem from the fact that they've succeeded.
This is Rogelio Rodriguez's last day in the Bexar County Outpatient Treatment Program.
Try to shake your hand, brother. And I know it's not much, we don't have much of a budget, but everybody got together and we signed this certificate of completion. And we want to hand it and tender it to you for all the hard work. I mean, all this was you, it wasn't us. Okay? And stay on those meds. And then the other thing we're gonna do is, this is kind of a tradition that we have here. A long time ago, the first person we graduated asked us if we were gonna give him a cake, right? Well, we didn't have a cake handy, so we gave him, one of the staff was eating a muffin and handed it to him. And it became such a tradition that this is your graduation muffin. Now, you can pretend we went out and baked it for you.
I owe it all to you guys, because without y'all, I wouldn't be the person that I am today. That's really coming from the heart. And thanks a lot for you guys.
And thank you for
Thank you, that was so nice.
I'm so proud of you, man.
Yeah.
Congrats, that's it.
Great
All right, my
job.
brother, be safe.
I have another video I'm going to show in a minute. But okay, yeah, don't go far. Okay, so let me just jump to my PowerPoint now. It's going to play again. Sorry, guys. I know we should have a slicker way of dealing with all this. Black Robe effect, here we go. Okay. Slideshow from beginning. Okay, we're good. Okay, so from those clips, I hope you got a lot out of seeing that, and I hope that it's now crystal clear, if it wasn't before, that there's nothing scary about this. Could I have the lights back on so I could see everybody? Thanks. This is not about court order or twisting people's arms, scaring people into submission. This is really a feel-good process. This is something that people who participate in get a lot out of and look forward to. Look forward to coming back to court for the most part, especially when things are going well, because they're going to get positive affirmation from the judge and from the treatment team. And it's so much more about that. And for all the people who say this is coercion and this is a terrible thing you're doing to people, whenever I'm in a court that's practicing AOT and I see this stuff, I always wish that those opponents would come with me and just sit there and watch it, and I think a lot of those concerns would melt away. So I'm really glad to have an opportunity to show some of this video to you. And this controversy, I think, very often leads us into this debate that sometimes roils the mental health field, this sort of choice. I feel it's very often a false choice that's presented between the recovery model and the medical model, right? The recovery model idea being that self-direction is the key to recovery, and the medical model being focused on the idea that you solve people's problems the way you do any other medical problem. You give them drugs and medication and makes it all go away the same way you treat any other medical condition of any other organ of the body. And, I think it's just one of the many debates in our society where it's like extremists on both sides who are completely missing the point, which is that, the reality is very much in the middle, that it's not all one thing or the other. And when you, exclude one perspective on how we deal with a particular person's care, you're doing a real disservice to your patient, your client, And so I don't really see, because, you know, AOT is seen as this paragon of the medical model, right? And not focused on recovery because it's taking that volition away from the person. And I don't see it as a rejection of the recovery model. I think, you know, to make this work best, we actually are maximizing the opportunity to involve the person in their care to the greatest extent possible. I see it as sort of a rejection of recovery model extremism, because we're acknowledging there are situations where a person can't self-direct and we have to make that decision for them. But every opportunity along the way that we have to engage the person and involve them, including, for example, the development of their treatment plan that gets presented to the court, you know, you don't just dictate to the person. You sit down with them as a clinical caregiver and you say, well, what's worked for you in the past? How can we make this a plan that you think is going to work? So, you know, as I say, with most things, we get to that right place by trying to bring in all perspectives. And I wish that this need to do this was more greatly, more widely acknowledged. You know, we have a statement that was put out and cited very often by SAMHSA, the Consensus Statement on Mental Health Recovery, back in 2006, where SAMHSA went out and spoke to a whole wide spectrum of mental health stakeholders, lots of different groups, lots of perspectives, and came up with this statement of 10 principles of recovery that they said are, you know, universally agreed upon. And number one, top of that list was this idea of self-direction, right? Consumers lead, control, exercise choice over, and determine their own path of recovery. And then that last sentence, which to me is the kicker. By definition, the recovery process must be self-directed by the individual, who defines his or her own life goals and designs a unique path towards those goals. Now, I have no problem at all with that as a general statement, as something we want to strive to maximize in every situation. But when they go so far as to say, by definition, the recovery process must be self-directed, you know, if we're going to acknowledge that there are people who cannot self-direct due to lack of insight and other factors, if that's really true, that means that recovery is not available to everybody. Recovery, we're going to basically write off people who can't self-direct because, by definition, the recovery is not within their grasp. And I have a problem with that. I don't believe in taking our commitment to the recovery model that far. And I want to just show you another piece of video. I'm going to come down there and start playing with the computer again, because I want you to see the practical impact of taking that extreme an approach to recovery when you are dealing with people who are under AOT court orders. And this is a piece of video from kind of an anti-AOT conference that was held in New York. And the gentleman speaking, his name is Steve Michio. He's the director of a peer support group in upstate New York that in their county actually has a contract to provide certain services to people under AOT orders. They are one of the providers taking part in AOT services. In this case, he's talking about the fact that they provide representative payee services to certain AOT recipients. That is, the benefit money that comes into these individuals from the government is handled through his organization. They distribute that money to the individual in a responsible way, or so they're supposed to under their contract. And Steve is going to describe here a situation that he actually feels is kind of a happy ending story, a heartwarming story about how he dealt with a particular client under AOT with providing these representative payee services. And, you know, I just hear such a different story. You know, he's seeing a glass as half full, and I'm seeing it as half empty. And we'll watch the video, and we'll kind of break it down, see if we can make sense of it together. I think we're going to need this mic on the speaker again. Would you mind holding? Okay. All right.
Now, I hope there's no mess that's in here. When I first started this, we had a guy that came in, and he was an AOT person, IOC person, whatever you want to call it, and we had to control his funds. And he comes in and he says, "Steve, give me my effing money." I'm like, "Well, here's your salary, here's your money for the week. It's $10, $15, whatever it was. It was a very low amount of money for him to live on." He says, "No, I want all my money." And he was threatening, and every month he would come in and threaten. So I thought about it. I said, "Well, what's the risk? I know he's a drug addict. I know he drinks. But what's the risk? Well, he could die. Well, that's all right, but that's his choice. So what's the risk?" So the next month I said, "You know what? I'm going to give him all his money." And I did. I couldn't pay his rent because I gave him all his money. So now the next month he was homeless. But after I gave him his check, 2 days later he came in, drugged out, and said, "I'm out of money. You got to help me. I have no food. I have no water." And I said, "How's that working for you?" And so I put it back on him to say, it was your choice. You wanted it, I gave it to you. How's that working for you? You like that? The next month he was homeless. It was even worse. Comes back in, he wants all his money again. So well, remember last month? I didn't give you all your money. And, yeah. Well, here's all your money again. See you later. Comes back a few days later, same thing. Drugged out. I need more money. How's that working? See you next month. 6 months later, he comes in and says, "Steve, you got to take care of my money." He says, "I'm not going to do this." That was his decision, his self-determination, his failure, his right to fail was doing that. And so often we respond and react because we think we have to protect people. We have that paternal instinct because we're humans. But we have to let go of that sometimes. We have to give people the education that they deserve. We should give them the information they deserve, and then give them the choices, but give them time to make those choices. Now, I hope there's no mess that's in here. When I first started this,
Okay, let me just get my PowerPoint back up. Where'd it go? Here we go. No. Oh, sorry, guys. Okay. Right. How's that working for you? Okay. So, I don't want to, we get the lights back on again? Thanks. So, look, my intent here is not to demonize Steve Michio or ridicule him. I've actually met him. He's a nice guy. I think he gets up in the morning and does the work he does for the same reason I do. We all do. I think he's trying to help people with mental illness sincerely. Lisa, would you mind putting it back on slideshow mode? Thanks. Just say continue from current slide. But I do think he's severely misguided, and I don't see the story quite as happily as he does. Sorry. Yeah, slideshow on the top. Yeah, there you go. And then from current slide. Perfect, thanks. So, what his approach basically is to let his client learn the hard way and come around. And in this case, thank God, this guy came around eventually and, survived it. But, the essential problem here is he's failing to recognize this problem as medical in nature. He is so opposed to the medical model of mental illness treatment that he's just seeing this as a behavioral problem, right? And it can be addressed through behavior modification, not seeing this person as having an illness. So, he asked this question again and again, how's that working for you? And I think we can put that question back on him. How well did this work out in this story that he tells? So basically, this individual, before he came around and said, "Steve, this is not working for me, you better manage my money," went through 8 months of hell. This is, this was month after month after month. You add up his story, he's talking about 8 months that this person spent homeless and living hell, right? Hungry, cold, filthy. 8 months of potentially irreversible damage taking place to this person's brain, right? Because all this time their severe mental illness is not being treated. We know they have a severe mental illness, even though he doesn't talk about it much, because they wouldn't have been able to get under AOT in New York if they didn't. So all that time without treatment is driving recovery further out of reach because we don't have the luxury of waiting around to treat psychosis mental illness. 8 months this person spent in daily exposure to all kinds of life-threatening hazards. Could have overdosed at any time, could have been the victim of violence at any point on the street, as we know our population so often is. And, you know, God knows what this person was doing over the course of these 8 months to raise the money to meet their basic survival needs once the money that Steve handed them at the beginning of each month ran out. You know, Steve acknowledges that all these risks are real. He says at one point in there, and I just want to point out a couple of things that I think speak to how misguided this approach is. He says, well, he could die. That's all right, though. That's his choice. And, you know, I just categorically reject that. I don't see it as a choice. When a person, to make a choice, you must have full information, right, coming into your mind. You weigh the pros and cons, and you make an intelligent choice, right? A person with cancer often has a very difficult choice to make whether they want to accept chemotherapy to prolong their life, right? But that's a choice they're making with information. He probably sees this the same way. It's not the same thing because the information isn't coming into the person's mind. They don't understand their own need for treatment. And so they're not exercising choice in a rational way that we would relate to and recognize, in my opinion. And this again brings us to this slide on anosognosia. It's simply not happening. He also argues that we have to give people not only choices, but also time to make those choices. And I would argue we don't have that luxury. As I've said already a little bit, this person is experiencing mental illness that's getting worse with each day. Their prospect for recovery, the opportunity that we have to restore them to the life they would choose if they could, is slipping away from us when we let them remain in the street in this condition. Treatment delay equals disaster. We have lots of studies that tell us that. The longer a person waits for treatment for a psychotic episode, the longer it takes to get that illness into a remission, the lesser chance that you will ever restore the person to the condition they had previously. And so, based on this, what I would encourage you to do in setting up your own AOT programs is not to take the Steve Michio approach. Embrace the black robe effect without apology. And this doesn't have to mean that you're simply ordering the person around and dictating to them what their treatment should be, because as you saw from the video I showed before, that's not actually what AOT looks like in practice. So you want a person to feel that a judge has said they need to do it, and they're doing it because the judge has told them so, but at the same time the judge is interacting with the person in a way that is making clear that the judge is on their side, right? So the judge's demeanor with the individual is critical. You want to lean towards being inspirational, not scary. Sees every opportunity to praise the person and reward success, even if it, just the little bit of success a person might have had since the last time you saw them. Jump on that as a judge and make sure the person knows that you're proud of them. Never let the patient forget that the judge is as committed to the quality of care as they are to the patient's compliance with the treatment that's been offered. One of the most effective things that judges often do at an AOT hearing, at an initial hearing, is to actually say to the person, I'm putting these folks that are around this table, this treatment system, I'm putting them under court order too, because you have an obligation to us, but they also have an obligation to you. And if at any point you are not getting the treatment that you deserve as a human being and that has been incorporated into this order I'm issuing today, you need to let me know about that. I want to know if I need to hold their feet to the fire. Telling that to a person as you're placing them under AOT is enormously empowering. So this black robe effect has sort of ripple effects of its own, right? It's not just something that the judge leverages. It's also something that those of you who are providers can also extend on and leverage as well. And, there are different ways you do that. One thing you might, if you're encountering a patient that is resentful of the treatment and maybe at one particular time is, expressing resistance to it, say, hey, not me, it's the judge. The judge says you got to do it. I'm in the same boat as you. I got to follow what the judge told me to do, just like you got to follow what the judge. So let's, work together to make the judge happy. If the patient at that moment wants to think the judge is a jerk, you don't have to argue with the person. work with it. And always keep in the client's mind that there is another court appearance coming up, right? So when things are starting to slip away, remind that individual, hey, in 2 weeks we're supposed to go back and see the judge again. You want to tell him something good, right? I sure want to tell him something good. And use that in your favor. Another way that I think a lot of programs have extended the significance of this black robe effect and helped a client to feel this sense of necessity of complying with the treatment plan is to involve CIT officers. If you have a CIT unit within your police department, they are terrific partners and I think a really important stakeholder. And in fact, the stakeholder group that Lisa talked about earlier should really include the commanding officer of your CIT unit if you have one. So what you really want is if you have officers who are out there in the community whose beat is the people with severe mental illness who have caused themselves and others distress in the past, you want those officers to be aware of who among the mentally ill people who they interact with regularly and are getting to know, right, as part of their regular duties, you want them to be aware of who's under an AOT order. Because if a situation arises where they're observing some conduct that suggests the person is not following the order, that's information that that police officer can make intelligent use of and bring to the program's attention, and that's how it gets back to the court's attention, and it might lead to having to bring the person back for an unscheduled hearing to try and nip things in the bud. So to make that police officer a partner, there is sometimes concern that you could be violating HIPAA by revealing to the police department that this person has this legal status of being under an AOT court order. That's actually an easy thing to overcome because within the HIPAA law, the HIPAA privacy rule, which says that generally people's protected health information is not to be shared outside of the provider community, provider world, there are a number of exceptions that are listed within those federal regulations. And one of the regulations that's relevant here is disclosures for law enforcement purposes. That is, generally this is used like if there's a need to disclose medical information to police because it's going to help them solve a crime, you can do that generally. But even in a situation such as having someone under an AOT order, which doesn't fit into that mold, there is a provision that says that a covered entity, this is within the law enforcement exception of the privacy rule, a covered entity may disclose protected health information for a law enforcement purpose to a law enforcement official in compliance with and is limited by the relevant requirements of a court order. That's right there in the Code of Federal Regulations, citations up on the screen. What that basically means is that if you put in the court order that if you're in a jurisdiction that has a CIT unit and you want this CIT officer to know that you have somebody under AOT, you have the judge order that, right? Put it right in the court order that this information shall be disclosed to the crisis intervention team unit of our police department, and maybe even name those officers if you can. That solves that problem because it then becomes, it's clearly within this disclosure for law enforcement purposes exception to the HIPAA privacy rule. So that's what I have for you today on the black robe effect, and we have some questions. Yes, sir. Yeah. Sorry, I'm having trouble hearing you. Could you bring him a mic? Thanks, Janet.
Understand about the HIPAA requirement, but under 42 CFR Part 2, which is dealing with drug use and alcohol use information, it's a higher protection standard than HIPAA. And some of these people who are coming into AOT may have co-occurring things that are going on that include
disorders, yep.
So how would we work around that?
Yeah, I mean, it's not a point I was aware of, so I'll take a look at that. But I would say off the top of my head that if you're describing, and I don't doubt that you are, the law accurately on disclosing information about a person's addictions, it might be that you cannot disclose information about the addictions specifically under this exception. This applies only to HIPAA. But what you certainly can still do is disclose to the police officers that this person is under an AOT order, right? Because the AOT order is simply about their mental illness. That is protected health information that's not related specifically to drug and alcohol addiction, even though that person may have those issues. Yeah. Yes?
Wait, if you could wait for the microphone. So.
Under AOT law, the physician's report to the court, how does that intersect with HIPAA law?
I'm sorry, I didn't hear you.
The physician's report to the court as part of a AOT petition, how does that intersect with HIPAA law?
Well, the AOT proceeding is like an inpatient commitment proceeding, right? An inpatient commitment proceeding also has a physician's report to the court and medical testimony that's given. And so that's a closed hearing under your law, I believe. It certainly is in most states. It's closed to the public. It's only, people can't just come and sit in the courtroom unless the patient agrees to have them there, right? So this is taking place as a confidential proceeding, and it's protected from prying eyes in that way. It's in the court record, but it's not a public court record, right? It's not a searchable court record. Any others? Otherwise, I guess we're right in line to take a break. So thanks, guys. We'll reconvene at 2:30 and have our AOT hearing. Thanks.